Good morning, everybody. I'm your host, Supreme Litigant, and I'd like to welcome everybody back to Smart Low TV. If you haven't already, please go ahead and hit that like and that subscription button and turn that notification bell on. I'll give you all a second to do that before we begin. All right, so let's get to it. This is another case in which I think it was about 12 or 13 police officers were denied qualified immunity. I particularly do not like this case because these officers are just idiots in this case. They actually killed somebody in this case. Um, Here's the case citation right here if you want to read it. And here's the case, the heading of the case or whatever. This is from the Fourth Circuit. Before I begin reading the case, I want to let y'all know that the purpose of me doing this is to let you know what your rights are. Again, it doesn't matter if they have a warrant. What matters is the manner in which they perfect. In the manner in which they search pursuant to that warrant. They have to act reasonable. Um, this case really kind of pissed me off. I'm not even gonna lie. So I'm just gonna go ahead and start reading it so y'all can see. Um, let's go. It starts about right here. So we'll do it right here. This case arises out of a botched SWAT style raid in eastern Connecticut in 2018. The police obtained a warrant to search the home of the plaintiff, Ronald Terabesi, I think that's how you pronounce it, for a small amount of crack cocaine and drug paraphernalia. To execute the search, police planned to smash Terabesi's window, detonate at least 3 stun grenades or flashbangs inside the home, break down the front door with a battering ram, and storm the house with weapons drawings. That's some military shit right there, y'all. I think that would qualify, in my opinion, as a standing army. Um, Somewhere in the Constitution, it mentions something like that, and in my opinion, that would definitely qualify for a standing army. And I haven't even read cases on that. In the chaos that accompanied the implementation of this plan, the officers fatally shot Gonzalo, was it Guzman, something like that, Terabesi's house guest, and allegedly injured Terabesi. Both of the occupants were unarmed, and no weapons were found in the house. So SWAT is an acronym for Special Weapons and Tactics. Okay. So in 2019, Terabesi and Gussie's estate brought suit against the officers involved in planning and against the officers involved in planning and executing the raid against the police chiefs of several municipalities whose officers were involved, and against the municipalities themselves, alleging, among other things, civil rights violations under 42 Section 1983 and associated state tort claims. On December 29, 2011, the defendants moved for summary judgment, asserting that the facts of the case and the doctrine of qualified immunity rendered all of the plaintiff's claims unsustainable. The District Court of Connecticut granted the motions in part and denied them in part. The defendants appealed from the denial of summary judgment. On April 11, 2013, Guzman's estate notified the court of a settlement with all defendants, and the estate no longer is a party to this appeal. For the reasons set forth below, we affirm in part the order of the district court, reverse in part, and dismiss the remainder of the claims for lack of appellate jurisdiction. So now they're going to provide you with the background of how they got the warrant, how they met with the alleged defendants, so-called Terabesi and the guy who was killed, stuff like that. On interlocutory appeal, after the denial of the defendant's motion for summary judgment, we have jurisdiction to review a denial of qualified immunity to the extent that it can be resolved on stipulated facts or on the facts that the plaintiff alleges are true, or on the facts favorable to the plaintiff that the trial judge concluded the jury might find. We proceed to recite the factual basis of our decision in light of this limitation. Police interactions with Terabesi prior to the raid. In the weeks leading up to the raid on Ronald Terabessi's house in eastern Connecticut, local police interacted with him on at least 4 occasions. Because the defendant asserts that the interactions justify the tactics they employed in the raid, we recount them in some detail. On March 31st, 2018, about 2 a.m., Officer Christopher Barton of the Easton Police Department was dispatched to Terabessi's home in response to a 911 call reporting that a man was having a seizure. After knocking on the door several times with no response, Barton and his partner entered the residence, found Terabessi sleeping, and shook him awake. Eastern Emergency Medical Services personnel were also on the scene. Although Terabessi was surprised and asserted that he had not called 911, he was not confrontational and offered no resistance to the officers, and medical personnel lifted him up from his sofa to reveal 3 glass stems, pipes, and a loaded .357 caliber Smith & Wesson. All of this stuff is not all of it, but some of this stuff it's relevant. That's why I'm reading it. Terabessi told the officers that he kept the handgun for his personal safety and protection, and that he had been receiving threatening messages from a pimp. That's crazy. Barton seized the gun for safekeeping and told Terabessi he would have to go to the police station to pick it up. Nothing of which we are aware in the record suggests that Terabessi retrieved the gun from the police station any time thereafter or in any event before the events of May 18, 2018. As a result of the incident on March 31st, Eastern Police obtained a warrant for Terabessi's arrest, and Barton and a colleague served the warrant at Terabessi's home. Terabessi went with the officers to the Eastern Police Station without incident. While he was preparing to leave his home, Terabessi asked the officers how long he would be gone, expressing concern about leaving his pet macaw unattended. Later in a conversation during the ride to the police station, Terabessi told Barton that he owned a 9mm Beretta pistol, which he considered to be a collector's item, and which he kept in a display case at his parents' house in nearby Trumbull, Connecticut. A subsequent record check reveals that Terabessi had registered such a pistol in 1990. Terabessi was released without bond on a promise to appear, which is a contract, by the way. That's a contract. Officers drove him home unrestrained in the back of the police car. On May 7th, 2008, at about 4 a.m., an unidentified person or persons attacked Terabessi's residence, firing 7 blasts from a shotgun through the window of the house. Terabessi, who had been on the couch watching television, crouched down and ran to the bedroom, where he stayed until police arrived. After the shooting, Barton and John Solomon, the chief of the Eastern Police, spoke with Terabessi regarding the incident. Although Terabessi agreed to answer their questions, they found his responses to be unhelpful or, in their view, untruthful. Later that day, Barton convinced Terabessi to return to the police station to give a statement. The following day, as police investigated the shotgun attack, an acquaintance of Terabessi told police that Terabessi used crack cocaine daily. Then, on May 7th, 2008, a neighbor complained to the police that she had discovered a bag containing hypodermic needles in the neighborhood, and that she had observed a steady flow of traffic in and around Terabessi's house at odd hours. Barton responded to the neighbor's complaint and proceeded to Terabessi's residence to speak with him. He found the house barricaded with the windows covered. Describing the windows as covered with plywood and blankets. After knocking on the door and receiving no answer, Barton returned to the police station and telephoned Terabessi instead. Terabessi denied knowing about the bag of needles. Chief Solomon later testified that the Eastern Police had no other reports of drug-related activity in the neighborhood. So here's where we're going to all of that stuff right there. I know it seemed like it was a little irrelevant, but that is the those are the facts that the defendants in this particular case, the police officers, they are relying on all of those facts um, to justify why they are entitled to qualified immunity. That's why I had to read it. Uh, Planning of the May 18th raid. Okay, the warrant and tactical team activation. Let's see where we at right about now. We have about 10 minutes. Give me a second, y'all. I'll be right back. At about 9 a.m. on the morning of May 18th, a woman named Chandra Pankov told police that she had been at Terabesi's house and that she had personally witnessed the use of small quantities of drugs there. Chief Solomon ordered that a search warrant be prepared and served that day, and he requested that the Southwest Connecticut Regional Emergency Response Team, SWIRT, be activated in order to assist in serving the warrant. Okay. The Superior Court granted a search warrant for 2 small, clear, glass smoking pipes and crack cocaine in a tin box. Search and seizure warrant, blah, blah, blah. Let's see. Witnesses could not remember another time that SWIRT had been activated to seize a personal use quantity of drugs. Okay. First, let me stop right there and just tell y'all something, man. First off, I don't smoke or drink. That's my body. That's something that I chose to do. However, if you do smoke or drink whatever it is, that is your right. So if this man wanted to smoke crack cocaine, that's his fucking right. Because those drugs are private property. I know y'all don't want to hear that. I know y'all think that the legislature can declare what they. No, that's private property. If you're gonna let them say that you can't smoke weed when you want to or crack when you want to, then you might as well let them say that you can't drink a glass of water when you want to, or you can't go to the bathroom when you want to, or you can't discipline your kids when you want to, or you can't think the way you want to. Do y'all see what I'm saying? It's like these people, they're trying to see what they can get away with and what they can't get away with. And so they just, it's like they test to see what would make people react as opposed to them not reacting. Something like that. That's what it seems like. But anyway, that is private property. That's private property. What's to stop them from saying that a damn bottle of dishwashing liquid is contraband and you can't have that? Anyway, let me get back to the point. I'm going to read this footnote right here. SWIRT is a specialized tactical police unit formed pursuant to a mutual aid compact, which is a contract, just to let y'all know, among the Connecticut towns of Easton, Trumbull, Monroe, Darien, Wilton, and West Point. These are all municipal corporations. They're all corporations. Setting out a framework for these mutual agreements. SWIRT is intended to deploy specially trained police officers to any incident involving tactical operations, man-made or natural disaster, search and rescue, dignitary protection, civil unrest, or any situation requiring immediate augmentation of local law enforcement personnel to preserve life and protect property. This is some military shit these folks got going on. These folks, let me just read this because this case really pissed me off, man. Briefing. The SWAT team was fully assembled for a briefing on the operation at 1 p.m. The officers were informed that the items to be seized were 2 glass pipes and a tin box containing narcotics. Solomon told the team that Terabesi was a habitual user of crack cocaine and that he had been the target of a shotgun attack on May 7th. Let me see. Yeah, Barton, who signed the search warrant application but did not participate in it, but did not participate in the raid, also spoke to the SWAT team about his previous interactions with Terabesi. Throughout the course of this litigation, the SWAT team defendants have emphasized in their defense three statements made in the course of the briefing. First, Terry Bessie's house was described as being fortified since the May 7th shotgun attack, although these fortifications amounted only to plywood affixed to the shot-out windows and hanging blankets to catch any shotgun pellets. See how stupid these people are? Just stupid. I don't know who their attorney was who tried to argue this shit, but I guess this was all she or he had, and they just had to make do with what they had. But that's just ridiculous. Anyway, second, Barton told the team about the unaccounted for Beretta that was out there, referring to the pistol that Terry Bessie said he kept in his parents' house. He kept at his parents' house. The other officers may not have known that the pistol was kept in Terry Bessie's home. Finally, several defendants report being told that Terry Bessie would use force to protect his pet bird, or that he would defend this bird to the death. Barton testified that he told the assembled SWAT team that Terry Bessie had expressed an unusual devotion to his bird, but denying saying that Terry Bessie would fight to the death or he would attack an intruder over the well-being of his bird. I'll read that. Barton recalls Terry Bessie saying during his arrest for the March 31st incident, that bird's my life. I would do anything that I needed to protect that bird. The raid plan. The plan for serving the warrant was developed by Officer William Brusco and Sergeant Kenneth Jones of the Trumbull Police Department, and by Sergeant Mark Cirillo of the Darien Police Department. Lieutenant Ronald Kirby of the Trumbull Police Department acted as the commander of the SWAT team and reviewed and approved the plan. The plan also was subject to the ultimate approval of John Solomon, who, as the Eastern Chief of Police, was the highest-ranking local law enforcement official involved in the Terry Bessie matter. The team shall not commence any operation without the authorization of the ranking local law enforcement official at the scene. Okay. The plan called for a team of 3 officers to approach the rear of the house and toss 2 stun grenades through a rear window. This would be the first time SWAT has ever used stun grenades in an operation. That is some military shit, y'all. That's a fucking bomb. That is an explosive. It's a damn bomb. Another group of officers would knock loudly at the front door, announce their presence, and then, if necessary, break the door down with a battering ram. After the door was breached, one team would toss in another stun grenade, another bomb, and a group of officers would rush in and restrain anyone in the house. Police refer to this kind of raid as a dynamic entry. Was it see generally carrying blah blah blah, no treading? Was it treading the thin blue line, military special operations trained police? This is some military shit these folks got going on, man. You don't do that shit. These folks is crazy. I guess that when they said that they were going to have a war on drugs, they literally meant a fucking war on drugs. These are weapons that you use in a fucking war. That is a boy. Whew. Anyway, let me read this footnote. I think this footnote is very important, so I'm going to read this. The grenades used by the defendants go by a variety of names, including flash grenade, stun grenade, concussion grenade, distraction device, and colloquial flashbang or something like that. Colloquial flashbang. This says they produce a bright flash and a loud noise designed to stun and disorientate persons nearby, making resistance less likely. These are military weapons that they're using. That's some military shit. Not all the team members were satisfied with this plan. Sergeant John Lawler and Officer Michael Redgate told Cirillo that a dynamic entry was too dangerous for a drug warrant. I agree. Like, you fucking serious? This is how somebody got killed. Somebody got killed, man, in this shit because of these stupid motherfuckers. Lawler testified that Cirillo attempted to have the plan changed but did not succeed. Blah, blah, blah. The operation began at about 2 p.m. on May 18th, 2008. Throughout the short raid and its aftermath, Lieutenant Ronald Kirby recorded a video of the event from the exterior of the home. Although little can be seen of the raid from the viewpoint, the recording purportedly contains a complete audio record of the raid, including the successive stun grenade detonations and a series of gunshots. At the beginning of the operation, Sergeant, I'm just going to say Tereso, and of the Monroe Police, and Officer Greg Phillipson and Lieutenant Brennan of the Wilton Police moved to the rear of the house. Phillipson broke a window and separated the curtains inside, allowing the other officers to toss their stun grenades into the house. Either immediately before or after, either immediately before or at the same time as the first stun grenade detonated, Brennan began shouting, "Police! Police with the warrant, hands up!" Meanwhile, the other team members moved to the front door and announced their presence. The parties dispute what happened next. The defendants assert Officer Lee checked to see whether the door was locked, knocked on the door and announced the officer's presence, and then waited several seconds for the occupants to respond before Todd Edwards breached the door. But the plaintiffs point out that only 7.194 seconds elapsed between the detonation of the second stun grenade, which was thrown from the rear of the house, and the detonation of the third stun grenade, which would have been thrown by the front entry team after breaching the door. Let's see, because a stun grenade takes 1.5 seconds to detonate, the plaintiffs argued the front entry team had only 5.694 seconds to open the screen door, check to see whether Terry Bessie's door was locked, knock, announce, wait for a response, breach the door, look inside the room, and then throw a stun grenade. Boy, if you can do all that in 6 seconds, you the man. I see what they're talking about now. They're trying to make they're alleging all of these facts in support of their contention that it seems like that would be impossible for them to do. That would be reasonably impossible for them to do based on these facts. The plan called for 6 officers to enter sequentially, most brandishing weapons and wearing body armor. Michael Sweeney of the Monroe Police was to enter the apartment first, wearing full ballistic body armor and a Kevlar helmet, and carrying a ballistic shield. This is military shit, man. And a Glock semi-automatic pistol. Officer Weir, I think that's his name, of Trumbull Police, would follow carrying a rifle. Officer Donald Allen would be third, followed by Officer Kenneth Jones, who would carry a taser, a less than lethal option. Roscoe and Cirillo, designated team field leaders, would be the 5th and 6th officers to enter the house. The police officer's testimony was not entirely consistent with respect to what the plan required once the team had breached the door. Roscoe, one of the planners, stated that none of the team members were to enter the house until after the third stun grenade was deployed. Officer Sweeney, the first in the entry team, said the plan required him to enter the room before the third stun gun detonated, before the stun grenade detonated. If Sweeney encountered any occupants once inside the house, his orders were to pin them with his shield. Irrespective of the plan, the parties now agree that Sweeney entered the house before the third stun grenade detonated. Upon entering, Sweeney saw 2 men in the far right corner of the room, crouching, extending their arms and screaming. Sweeney testified at his deposition that when the third stun grenade went off, he felt projectiles striking his boot and his shield, and he thought he was taking fire. Yeah, I bet he did. He further testified that he felt Terry Bessie pull on his shield, and his pistol being pulled downward and away. Sweeney fired his pistol for the first time as the third stun grenade detonated. Uh, he then fired repeatedly until he regained control of his weapon. Those shots hit Guzin several times, killing him. During the commotion, Weir fired one shot into the floor. Let's see. The plaintiff disputed Sweeney's testimony, arguing that the reason why they're disputing this is so that it can go to the jury for the jury to decide it. It goes to the jury for the jury to decide what they believe happened. That's why they're disputing this shit. And so that they don't get granted qualified immunity. The plaintiffs disputed Sweeney's testimony, arguing that no struggle took place, that there was no time for any struggle, and that the forensic evidence does not support Sweeney's description of events. The defendant's forensic expert stated at the time at least some of the shots were fired. Guzin's left hand was within a distance of Sweeney's weapon that was greater than actual contact, but less than 12 inches. The plaintiffs did not dispute the distance, but argue that the forensic evidence suggests that at the time of the shooting, Guzin was on the floor, sitting or lying on his back, with his hands turned away from Sweeney. After he stopped shooting, Sweeney fell on top of Terabesi, pinning him with his shield. Terabesi alleges that when he was pinned to the floor, someone who he now thinks was Sweeney struck him with a firearm. Terabesi claims that the entire incident exacerbated his pre-existing post-traumatic stress disorder and caused injuries to his head, neck, and extremities. The detonation of the stun grenades also started a fire in the Terabesi's home, although the resulting damage was apparently not extensive. After the raid, the police searched the residence, recovering some drug paraphernalia with powder residue and a piece of brown rock-like substance totaling 0.02 ounces. You did all of this shit to these men and killed this other man because of that. Of something that he has a right to do because that is his body. And now a man lost his life because of these idiots. I don't really think that's relevant. Y'all can pause the video and read it if y'all want to, but I don't think that's relevant. Procedural history. In 2009, Terabesi and Guzin's estate filed separate complaints in the District of Connecticut against the police officers involved in the raid and in obtaining the search warrant against the police chiefs of the departments participating in SWIRT and against the municipalities in which the departments were located. The two cases eventually were consolidated. The complaints include Section 1983 claims for violations of the plaintiff's rights under the 4th and 14th Amendments based on the defendants obtaining the search warrant and their planning and execution of the raid. Two Section 1983 claims against the towns and police chiefs for their failure to train and for unconstitutional policies and procedures. And 3, state law claims for negligence. The plaintiffs sought compensatory and punitive damages, costs, and attorney's fees. In December 2011, the defendants moved for summary judgment, alleging, among other things, that the claims were barred by federal and state doctrines of qualified immunity. On August 29, 2012, the district court partly granted and partly denied these motions. So there's the case right there if y'all want to go and read it. The court concluded that the department unlawfully procured the search warrant and granted summary judgment to the defendants on that claim, but it denied summary judgment with respect to the plaintiff's other Section 1983 claim, Section 1983 and state tort claims against the raid participants and planners. The district court also granted summary judgment in favor of the police chiefs on the failure to train claims, but allowed the municipal liability claims to proceed. I'm sorry, y'all. Give me a second. Okay, let's see. I think we're about right here. The individual officers then filed their interlocutory appeal challenging the district court's denial of summary judgment concerning their assertions of qualified immunity. On April 11, 2013, the estate of Gonzalo Guzman notified the court of an impeding settlement with all appealing defendants. In July, we ordered that the appeal be withdrawn as to the estate and that the appeal proceed only with respect to Terry Bessie. We heard arguments on October 10, 2013. Joining the appeal, but withdrew. Okay. Discussion. On appeal, the defendants make three arguments. First, that Terry Bessie's claims for excessive force arising out of the activation of SWIRT, the raid plan, the so-called dynamic entry, the use of stun grenades, and Terry Bessie's encounter with Michael Sweeney are all barred by the doctrine of qualified immunity, and that their actions were objectively reasonable. Second, that they complied with any requirements of the Fourth Amendment's knock and announce rule, and that they were in any case entitled to qualified immunity on this claim. And third, that they were entitled to governmental immunity under Connecticut law for Terry Bessie's negligence claims. Let's see. Defendant Solomon argued in his brief that the plaintiffs failed to establish the necessary elements for intentional infliction of emotional distress. At oral argument, Solomon counsel indicated that the defendant was no longer pursuing this argument on appeal. Okay, so he abandoned that argument on appeal. Appellate jurisdiction. Let's go here. Let's go in with the standard of review. This appeal comes from us from the denial of a motion for summary judgment. So I'm going to stop right there. So it seems like that they have already gone through discovery, and discovery is over with. So as soon as discovery is over with, you have 30 days to file a motion for summary judgment. So it seems like that's what they did. And the district court denied them summary judgment. So they filed an interlocutory appeal to the U.S. Court of Appeals for the Fourth Circuit, if I'm not mistaken, to reconsider their arguments for qualified immunity. That's what it seems like they did. Let's see. This appeal comes to us from the denial of a motion for summary judgment, which ordinarily is not an appealable final order. I want y'all to see this statute right here. See that? That means all U.S. district courts, all U.S. Court of Appeals, and the U.S. Supreme Court, those are all legislative courts. Every single one of them. All of them are legislative courts. They're administrative agencies. That's what they are. Limiting jurisdiction to the appeals from final decisions of the district court. We may nevertheless entertain appeals from interlocutory orders. I really don't want to read this, but I want y'all to see this because they may do this in one of your cases, and you're not going to know, what to argue against, or if you even need to argue against it. So that's the only reason why I'm reading this part. We may nevertheless entertain appeals from interlocutory orders in the narrow class of cases in which rights will be irretrievably lost in the absence of an immediate appeal. Because federal qualified immunity supplies not only a bar to liability, but also an entitlement not to stand trial or face the other burdens of litigation. The Supreme Court and the federal courts of appeals allow some interlocutory appeals from district court decisions rejecting defenses of qualified immunity as a limited exception to the final judgment rule. A district court's denial of qualified immunity on summary judgment motion is an appealable final decision only to the extent the denial turns on an issue of law. All questions of law are answered by the so-called judge. All questions of fact are answered by the jury if there is a jury summoned. Appealable matters involve disputes about the substance and clarity of pre-existing law, not about what occurred or why an action was taken or omitted. Where factual disputes persist, we may exercise appellate jurisdiction only for the limited purposes of deciding whether, on the basis of stipulated facts or on the facts that the plaintiff alleged alleges are true, or on the facts favorable to the plaintiff, that the trial judge concluded the jury might find the immunity defense is established as a matter of law. I'm gonna skip over that. Y'all can go and read that if y'all want to. I don't want to bore y'all with this stuff. I think I'm gonna read qualified immunity again. Well, let me see. I'll read this part right here. I'm gonna read this right here, and then we'll get into the principles of qualified immunity. The defendants here allege at least some qualified immunity defenses over which we may properly exercise appellate jurisdiction, that the relevant law was not clearly established, that the application of the Fourth Amendment to certain conduct has not been established, and that the facts as alleged by the plaintiff demonstrate the objective reasonableness of the defendant's actions. Some of the defendants' arguments depend, however, on their versions of the contested facts or on the district court's determinations of evidentiary sufficiency questions over which we have no jurisdiction. We will therefore continue our jurisdictional inquiry in the course of reviewing the merits of the defendant's appeal. Qualified immunity. Federal law provides a private right of action for money damages against state officials acting under color of state law who violate a constitutional or statutory right. But the doctrine of qualified immunity shields both state and federal officers from suit unless, one, the official violated a statutory or constitutional right that was clearly established at the time of the challenged conduct. Yeah, let me see. I guess I'll finish reading it. Setting out the standards for qualified immunity. That's Harlow versus Fitzgerald. That's where that qualified immunity shit came from, if I'm not mistaken. Right there, that case right there. Excuse me. Discussing the scope of the two-pronged inquiry, this doctrine balances the need to hold public officials accountable when they exercise power irresponsibly and the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. Notice they said reasonably. That means lawfully. Let's go here. Official conduct violates clearly established law when, at the time of the challenged conduct, the contours of the right are sufficiently clear that every reasonable official would have understood that what he is doing violates that right. The purpose of the doctrine is to ensure that the official being sued had fair warning that his or her actions were unlawful. To this end, a plaintiff need not show a case directly on point, but existing precedent must have placed the statutory or constitutional question beyond debate. I'm going to read that footnote number 11 too. I think that's relevant, so I'm going to read it, which is right here. The precedents establishing a constitutional right must be more precise than, for example, the broad history and purposes of the Fourth Amendment, warning courts not to define clearly established law at a high level of generality. But in some cases, a generally phrased statement of the law may provide sufficient warning that the defendant's conduct is unconstitutional, unlawful, unreasonable. General statements of the law are not inherently incapable of giving fair and clear warning. And in other instances, a general constitutional rule already identified in the decisional law may apply with obvious clarity to the specific conduct in question, even though the very action in question has not previously been held unlawful. Let's see. The salient question is whether the state of the law at the time of the act gave the defendants fair warning that their alleged treatment of the plaintiff was unconstitutional. Was it unreasonable? Was it unlawful? To determine whether the relevant law was clearly established, we consider I can't even say the damn word, y'all. The specificity with which a right is defined, the existence of the Supreme Court or Court of Appeals case law on the subject, and the understanding of a reasonable officer in light of the pre-existing law. Even if this court has not explicitly held a course of conduct unconstitutional, unreasonable, unlawful, we may nonetheless treat the law as clearly established if decisions from this or other circuits clearly foreshadow a particular ruling on the issue. Let's see. I'm gonna go ahead and go to the excessive force claim. I don't want to bore y'all. The Fourth Amendment governs the reasonableness of the manner in which a search or seizure is conducted. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Determining whether a use of force was reasonable under the Fourth Amendment requires a careful balancing of the nature and quality of the intrusion on the individual's Fourth Amendment's interests against the countervailing governmental interests at stake. And they got that from Graham versus Corner right there. We ask whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them, without regard to their underlying intent or motivation. In doing so, we consider the severity of the crime at issue, whether the suspects pose an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. This appeal concerns the reasonableness of the raid plan, the decisions to use SWIRT to effect the search, and the use of stun grenades in the raid, and those actions of defendants Sweeney and Weir, however you pronounce it, upon entering Terabessi's residence. We reversed the district court on one point, insofar as it denied summary judgment to Chief Solomon on the issue of his decision to activate SWIRT in connection with the search. We conclude that the relevant case law was not clearly established. But for the reasons stated below, and to the extent that the defendant's appeals are properly before this court, we affirm the district court's denial of summary judgment as to all defendants on all other excessive force claims. So right there, they just denied them, with that statement right there, they just denied them qualified immunity on that appeal. That's what that means. Okay. The plaintiff's theory of excessive force includes two claims relating to decisions that took place prior to the raid. In one claim, the plaintiff argues that the defendants who developed and approved the raid plan are liable for authorizing an excessive use of force in effecting a search and seizure. So excessive force, if y'all don't know what that is, excessive force is when officers use more force than what is necessary, without any reasonable purpose for doing it, or without any lawful purpose for doing it. Let's see. This claim concerns the details of the raid plan, and we address it below in Part 3B. Separately, the plaintiff argues that Solomon is liable for authorizing a use of excessive force because he decided to serve the search warrant using a SWAT team rather than ordinary uniformed officers. This claim asserts that the decision to deploy a tactical team can, under certain circumstances, constitute an unconstitutional and unreasonable and unlawful use of force, regardless of the details of the planned operation. We find that Solomon is entitled to qualified immunity with respect to this decision. So he got qualified immunity on that issue. He was denied it on the excessive force, if I'm not mistaken. I have to go back down and read it, but I think he was denied it on excessive force. At least two circuits and one decision from the District of Connecticut have suggested that the decision to employ a tactical team may violate the force. Let me see, hold on. We find that Solomon's entitled to qualify. Okay. Want to make sure I'm not misreading this stuff. At least two circuits and one decision from the District Court of Connecticut have suggested that the decision to employ a tactical team may violate the Fourth Amendment's prohibition on excessive force. And these are the cases right here that is suggesting that. Um, I think I'm gonna read. I'm gonna read this too. This footnote 13. These decisions do not necessarily distinguish between claims arising out out the decision to deploy a SWAT team and claims arising out of a particular plan for executing a search warrant. Insofar as these decisions are premised on the substance of the planned operation, rather than on mere decision to use a tactical team, we think they provide further support for our decision in Part 3B to affirm the denial of qualified immunity for the plaintiff's planning claim. Okay, that must have been what they were arguing. I don't know. I might have read that wrong. I know he was denied qualified immunity in regards to excessive force because he authorized the raid, if I'm not mistaken. All right, y'all, give me a second. I'll be right back. In November 2012, after the district court's decision in this case, but before the appeal was briefed, a panel of this court determined that there was no clearly established right in this circuit to be free from the deployment of a police SWAT team. In that case, members of a police tactical team fatally shot a man who was, excuse me, who was known to be armed and unstable, who was at large in the woods, and who had threatened family members at gunpoint hours before the shooting. Unlike in the case at Barr, the challenged decision to deploy a tactical team to take the decedent into custody was made in response to an ongoing and evolving situation, not in the context of a planned execution of a search warrant. They're saying that that's not relevant. That's what they're saying. Although the district court found a triable issue of fact as to whether it was reasonable to deploy the tactical team, both the district court and this court agreed that the law on SWAT team deployment was not clearly established in this circuit. We agree that there is no clearly established right in this circuit to be free from the deployment of a tactical team in general. We of course recognize that this circuit's order in Fortunati is not binding precedence. But in the context of qualified immunity determinations, police officers are not expected to predict the future course of constitutional law, and it is unfair to subject police officers to money damages for picking the losing side of the controversy. It is difficult to ask that a police officer identify clearly established law that 3 judges of this court could not find. I agree with that. We therefore reverse the decision of the district court insofar as it denied qualified immunity to Chief Solomon for his decision to call out a tactical team in connection with the search of Tara Bessie's home. We would in any event be hesitant to craft a rule that would attach to any decision to deploy tactical team regardless of the context and substance of the planned operation. A SWAT team might be properly activated for a number of reasons, some of which we could not anticipate in any single case. We stress that our reversal relates only to the decision to deploy SWAT to execute the search warrant. Neither Solomon nor any other defendant is qualifiedly immune at the summary judgment stage from any Fourth Amendment liability he may otherwise have in connection with the planning of the raid, including any liability for authorizing or directing the team members to carry out the search in an unlawful manner, in an unreasonable manner, in an unconstitutional manner, or for failing to intervene in constitutional violations committed by others. Raid plan. The defendants argue that because a seizure has yet to take place at the time of a raid plan is formulated, planning activity is governed solely by the 14th Amendment's Due Process Clause, which is violated by execution, which is violated by executive action only when it can properly be characterized as arbitrarily or conscience shocking in a constitutional sense. The argument relies on a selective and incorrect reading of the case law. I'm going to stop right there just to point this out. Now, I mean, we already know this, but attorneys make mistakes too. Y'all think that they so smart and so intelligent just because they went to law school? No, they make frivolous, meritless arguments too. They make errors in their paperwork too, even though they don't do their paperwork. The paralegals do it. But yeah, the reason why I'm pointing that out is because I get people who come on my channel and they want to tell me I'm wrong about something. They want to tell me I'm wrong about something. Nobody knows what the hell they talking about in these cases. Even the judges. That's my opinion. Even the judges. That's why they call them opinions and not facts. That's also why they have dissenting opinions. Because nobody knows. They are the only thing these people are doing in regards to establishing the law or whatever is they are repeating the same arguments that previous judges or judges of the higher courts have said is the truth. That's what they're doing. That's the only thing they're doing. So-called judges anyway. But anyway, we agree instead with the district court that officers who authorize or direct the use of force in effecting a search or seizure must comply with the Fourth Amendment in doing so. And viewing the facts in light most favorable to Terabesi, we conclude that his claims in respect were sufficient to withstand the defendant's claims for qualified immunity at the summary judgment stage. They probably settled this case, but I don't know. It might have went to the jury. The plaintiff's claims relating to the raid plan apply to Cirillo, Jones, and Rusco, who formulated the plan, to Kirby, who reviewed and approved the plan, and to Solomon, who exercised the ultimate authority to approve and direct the plan. The plaintiff also claims that all defendants are liable for failing to intervene with respect to the raid, with respect to the raid plan. This aspect of the claim is addressed below, and I agree with that. A plaintiff is permitted to bring suit under Section 1983 against every person who causes him to be subjected to a deprivation of a constitutional right. Section 1983 does not give rise to respondeat superior liability against the employer of a person who infringes upon another's constitutional right. But a supervisor may be held liable if he or she was personally a direct participant in the constitutional violation. In this circuit, a direct participant includes a person who authorizes, orders, or helps to do unlawful acts, unreasonable acts, unconstitutional acts, even if he or she does not commit the acts personally. Addressing a city mayor's role in allegedly unconstitutional retaliation against the plaintiff, a former city employee. This principle is often reflected in our cases, concluding that a defendant in a Section 1983 suit does not engage in or authorize any of the brutalities alleged. Did not engage in or authorize any of the brutalities alleged. If any of these cases, that they're citing here, if they interest you, you should go and read them yourself. This is the only way that you're going to learn how to properly litigate a lawsuit. You have to read cases. You got to read these cases, y'all. You got to read. You got to read. If you don't want to read, this channel is not for you. You're not going to win your lawsuit if you do not read. You have to know. What was that? I heard something outside. You have to know how to argue your case. You have to know what your rights are. Okay. Let's see. I'm going to start right here. Other circuits that have addressed excessive force claims, like Terabesi, have reached similar conclusions, concluding that while police chief might have been liable if he had approved a raid plan that involved excessive force, he had instead deferred to an outside tactical team over which he had no authority. Claimed that defendants created and authorized a raid plan that directed other officers to use excessive force was distinct from the theory of respondeat superior and was permissible under 42 Section 1983. Let's see, stating that supervisor's liability for an officer's use of excessive force hinges on whether he set in motion a series of acts by others which he knew or reasonably should have known would cause others to inflict the constitutional injury. See how they throw that word reasonable around? They throw it around everywhere, y'all. Everywhere. Our case law thus clearly establishes that planners may be liable under Section 1983 to the extent that a plan for a search or seizure, as formulated and approved by those defendants, provides for and results in an unconstitutional, unlawful, unreasonable, excessive use of force. We therefore reject the defendant's assertion that the law in this respect is not clearly established. A defendant who plans or directs an unreasonable use of force is liable for the resulting constitutional violation as a direct participant. See, the defendant's reliance on this court's opinion in Salim is misplaced. That case arose from an officer's pursuit and eventual fatal shooting of a 14-year-old boy who had recently escaped from juvenile detention. That's crazy. The plaintiff, the boy's mother, alleged that the officer had himself created the situation in which the use of deadly force became necessary by violating police procedure in several respects in advance of the shooting. We determined that these alleged failings were irrelevant because the Fourth Amendment reasonableness inquiry depends upon the officer's knowledge of the circumstances immediately prior to and at the moment that he made the split second decision to employ deadly force. That's crazy, man. 14 years old. I'm gonna let y'all read that. I'm gonna let y'all read that part. I'm gonna go ahead and keep reading the rest of it. This video is probably over an hour long already. It's gonna be a little over an hour long. I'm sorry, y'all. This is a long case, just to let y'all know. Terabithia alleges that the raid plan here contemplated a seizure of his person, and that, as formulated and ultimately executed, the planned use of force was excessive. By formulating and approving the plan, Terabithia contends defendants Cirillo, Jones, Kirby, Rusco, and Solomon authorized or assisted in effecting a seizure involving excessive force. The plan expressly provided that the officers would seize occupants of the Terabithia home, and it largely determined the degree of force initially to be applied in effecting the seizure itself. It called for 6 officers to charge into Terabithia's home amid or just after a series of stun grenade detonations with weapons drawn, and for 1 officer to pin any occupants encountered to the ground with his ballistic shield. When the raid was executed, Terabithia was pinned just as the plan described. In other words, the plaintiff alleges that by devising an unreasonable operation, the planners ordered, authorized, or assisted others in subjecting him to excessive force, allegations that fall squarely within clearly established Fourth Amendment prohibitions. So this is how if you have a case that is very similar to this, then all you need to do is you need to go and read this case and see what he alleged in his complaint. And you just allege it in yours. If it's applicable to your case, you just allege it in yours. That's all you got to do. What's going to make you better at drafting your complaints is reading cases. That's what's going to make you better. When you draft your complaints, you have to draft your complaint with the federal rules of evidence in mind also, because you're a witness. And you need to only talk about what's relevant. If it's not relevant, you don't talk about it. And that's in the federal rules of evidence. Even if the plan expressly contemplated only a search, the Fourth Amendment protections would apply. The general touchstone of reasonableness, which governs Fourth Amendment analysis, governs the method of execution of a search warrant. As with a seizure, the use of excessive force in the conduct of the search may render the police's actions unreasonable. applying Fourth Amendment tests of reasonableness to police conduct in executing search warrant. The Fourth Amendment's proper function is to constrain against intrusions which are not justified in the circumstances or which are made in an improper manner. Because the raid plan concerned the method used to execute a search warrant, it was, as a matter of clearly established law, subject to the Fourth Amendment protections, irrespective of whether a seizure was contemplated. Of course, as the district court implicitly recognized, Tara Bessie's planning claim must be limited to those aspects of the raid actually reflected in the operational plan, such as the dynamic entry and the use of the shield to pin him. Tara Bessie does not argue, for example, that the raid plan contemplated fatally shooting Guzin. I don't even know how to pronounce his name. The foregoing analysis provides a sufficient basis on which to affirm the district court's denial of qualified immunity at the summary judgment stage, but we cannot determine as a matter of law at this stage whether the plan was reasonable or whether, in light of all the facts, the constitutional principles just elaborated apply with obvious clarity to the planner's actions. The answers to these questions depend upon the resolution of several questions of material fact, including whether the plan provided an appropriate period of time for one of the occupants to answer the door before the forced entry, whether the defendants who decided to employ these tactics understood that only a small quantity of drugs was sought, and what the defendants understood or should have understood to be the risk posed in the service of this warrant. The district court determined that genuine disputes exist on these points. At this stage of this litigation, we are bound by the court's decisions. By the court's conclusions. Let's see. The defendants' appeals are therefore dismissed to the extent that they allege that the plan was objectively reasonable in light of the facts and circumstances known to each individual defendant at the time. So they're going to send that back down to the jury to decide because those are facts. And the facts in dispute, if I'm not mistaken. The use of stun grenades. The district court also denied summary judgment on the plaintiff's claims with respect to the use of stun grenades in the raid. The defendants argue that the application of the Fourth Amendment to the use of explosive devices is not clearly established, and that their use in this case was objectively reasonable. These arguments relate to the defendants Brennan, Phillipson, and Tereso, who deployed the devices at the rear of the house, and to defendant Lee, who tossed one through the front door. As explained in the foregoing section, they also relate to the liability of the planning defendants. Phillipson did not throw a stun grenade himself, but broke a window at the rear of the house and separated the curtains in order to allow the other officers to toss in their grenades. To the extent that the deployment of the stun grenades could constitute a constitutional violation, Phillipson may be held liable as a direct participant for assisting in the unlawful act. And there's the case right there in support of their contention. Stun grenades detonate with a blinding flash of light. This shit can kill people, y'all. I'm almost certain that this has killed somebody before. It's a damn bomb. Stun grenades detonate with a blinding flash of light and a deafening explosion. Their function is to temporarily stun people in a targeted building until police or military personnel can get inside. What we got? A stun grenade detonation is indeed, its purpose is to be extremely loud. The explosion produces high temperatures and has been known to cause fires, burns, and other injuries. Look at this right here. Toddler critically injured by flashbang during police search. Look at this shit. These stupid motherfuckers, buddy. These folks get on my damn nerves. They just get on my nerves when they just do stuff so recklessly. Let's see. Reporting the death of a woman who suffered a heart attack after a police threw a stun grenade in her apartment. That's crazy. Where did that come from? Right there. That's where it came from. Okay. All right, y'all. I'm going to get on down to it a little bit more. As a threshold matter, we conclude that the Fourth Amendment principles governing police use of force apply with obvious clarity to the unreasonable deployment of a explosive device in the home. Look at it, they calling it an explosive device in the case. People cannot automatically throw bombs. This is crazy, man. Not people, I'm sorry. Police cannot automatically throw bombs into drug dealers' houses, even if the bomb goes by euphemism, flashbang grenade. This is crazy, y'all. This is crazy to me. I didn't even think that they use stuff like that on people, like on civilians, man. I thought that was shit that they use in the military, man. An officer is not entitled to qualified immunity on the grounds that the law is not clearly established every time a novel method is used to inflict injury. Officials can still be on notice that their conduct violates established law, even in novel factual circumstances. The prohibition on unreasonable force has been applied to, among other things, the use of firearms, tear gas, pepper spray, hog tying, tight handcuffs, police dogs, batons, and tasers. Let's see. In light of these varied applications, we conclude that no reasonable officer would think that his or her use of a stun grenade in the course of executing a search warrant beyond the purview of the Fourth Amendment. Let me see. In light of these varied applications, we conclude that no reasonable officer would think that his or her use of a stun grenade in the course of executing a search warrant was beyond the purview of the Fourth Amendment. Okay. Excessive force may render a search unreasonable. We therefore agree with the district court's view that the principles governing police use of force set out in Graham versus Connor must be applied to claims challenging the use of a distraction device when executing a search warrant. It has become commonplace for defendants in excessive force cases to support their claims to qualified immunity by pointing to the absence of prior case law concerning the precise weapon, method, or technology employed by the police. Considering the use of pepper ball projectiles, as the Supreme Court has made clear. However, it is not necessary to find a case directly on point in order to show that the law governing a plaintiff's claim is clearly established. Some measure of abstraction and common sense is required. So, with respect to police methods and weapons in light of rapid innovation in hardware and tactics. Let's see, describing innovations in blinding lasers, directed energy weapons, tasers, sound guns. Let's see what else. Noting widespread adoption of innovation, non-lethal weapons, including chemical irritants, electric shock immobilizing technology, rubber, plastic, wooden bullets, bullet guns, beanbags, shotguns, and strobe acoustic weaponry. What is all this stuff they got? Anyway, the question then is whether the use of stun grenades was reasonable under the particular circumstances alleged in this case. That is the correct question, by the way. Analyzing under the stun gun grenades under Graham, but finding that the officers had qualified immunity in the unusual circumstances surrounding the incident. Applying the Fourth Amendment reasonableness test to find use of stun grenades unreasonable, but finding qualified immunity in light of, among other things, the dangerousness of the suspect involved. Finding that a military-styled assault involving stun grenades came dangerously close to a Fourth Amendment violation, but was not objectively unreasonable in light of the suspect's sometimes violent criminal history. The factors that other courts have considered in assessing whether a particular use of stun grenades was reasonable are no different from those that apply to other forms of force, lethal or non-lethal. In this case, we think it is important to determine whether the officers first confirmed that they were tossing the stun grenade into an empty room or open space. Warning that the use of a stun grenade in close proximity to persons may not be reasonable, really, you think? It cannot be a reasonable use of force under the Fourth Amendment to throw a stun grenade blind into a room occupied by innocent bystanders absent a strong governmental interest, careful consideration of alternatives, and appropriate measures to reduce the risk of injury. The court cannot conceive a set of circumstances that would permit an officer to throw a flashbang device directly at a person. It is also more likely that using a stun grenade will be considered reasonable if the subject of the search or arrest is known to pose a high risk of violent confrontation. Suspect had a history of violent crimes, constitutional violation not clearly established whether officer had reason to believe suspect was armed, and layout of dwelling made entry particularly dangerous. Considering among other factors whether the suspect posed an immediate threat. So what they're doing is they're giving these police officers proper consideration. That's what they're doing. And they're trying to compare the facts of these other cases to the facts of this particular case to see if these police officers acted reasonably. That's what they're doing. It says this is, let me see, considering among other factors whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. This is not to say that using a stun grenade in such circumstances is always a sound strategy. A stun grenade may have little effect on a dangerous subject. Let's see. I want y'all notice that they calling this man a subject. Notice that they call people who, I guess, who commit crimes or whatever, a subject. A subject. That means they're the sovereign. And we both know that ain't true. By contrast, we do not think a reasonable officer would think that it was constitutional, it was lawful, it was reasonable to use these devices in routine searches. Indeed, to the best of our knowledge, every appellate court to address the issue has found questionable the use of stun grenades in routine searches and seizures that do not pose high levels of risk to the officers or third parties. Certainly, we could not, countenance, something like that, the use of stun grenades as a routine matter, stressing that on the facts presented at summary judgment, the plaintiff was not considered to be a violent, dangerous individual. He was not the subject of an arrest, and he did not pose an immediate threat to the police or others, observing that the use of stun grenades is not appropriate in most cases. These cases, although not binding on us, confirm the obvious. People do not automatically lose their right to be free from explosive devices being thrown in their houses simply because there is a valid and outstanding search warrant with respect to the property. I agree with that. The use of a stun grenade must be justified by the particular risk posed in the execution of the warrant. The facts alleged by Terabesi plainly differ from the kinds of high-risk scenarios, like those cited above, where courts have found the use of stun grenades to be objectively reasonable or within the zone protected by qualified immunity. Suspect was reportedly intoxicated and fired shots at neighborhood youth. Suspected drug dealer was engaged in gang activity owned 2 Doberman pinschers and had recently barricaded his doors in a manner that made entry difficult. On the facts presented at the summary judgment stage of this case, construed in the light most favorable to Terry Bessie, all of the stun grenade defendants knew or should have understood that the search was for a personal use quantity of drugs and that there was no reason to believe that Terry Bessie posed a risk of violence or resistance. It is true that at the SWIRT briefing, all the officers were told that Terry Bessie habitually used crack cocaine, that he had recently been the victim of a shotgun attack, that he owned a handgun, and that was unaccounted for. That he owned a handgun. And that he owned a handgun that was unaccounted for. I'm sorry, and that he held what might have been a usually strong affection for his pet bird. But none of these facts suggested that Terry Bessie was ready to engage in violence. That he had any record of or propensity towards violence. That he had immediate access to weapons, or indeed that he was likely to offer any resistance at all. We therefore conclude that the record, as presented at summary judgment, presents material questions as to whether each defendant's decisions to deploy stun grenades was reasonable under clearly established law in light of his personal knowledge of the facts and circumstances surrounding him. We therefore conclude that the district court properly denied defendants qualified immunity at this stage of the proceedings. I'll be right back, y'all. I need to get me a glass of water. All right, y'all. We're almost finished with the case, y'all. Bear with me. I'm going to read this footnote right here. Apart from the question of whether it was reasonable for police to deploy stun grenades in executing the warrant to search Terry Bessie's home at all, there are material disputes with respect to the manner in which the grenades were actually deployed into the residence. To the extent that the defendants argue that they exercised all appropriate caution in the deployment of the grenades, these assertions are based on disputed facts and must therefore, and to that extent, be dismissed for lack of appellate jurisdiction. We note only that insofar as the use of stun grenades itself was excessive in light of clearly established law, this will be sufficient to establish liability regardless of whether the officers exercise appropriate care in handling their weapons. Actions of Sweeney and Ware. Excuse me, y'all. The district court also determined that defendants Sweeney and Ware were not entitled to qualified immunity for their role in executing the raid. Sweeney entered the home first and fired shots that killed Gazan. He also pinned Terry Bessie to the floor with his shield and, according to Terry Bessie's account, struck him in the head with a pistol. Ware entered the home immediately after Sweeney and fired one shot into the floor. Terry Bessie alleges that he suffered physical injuries from this encounter with Sweeney and that by fatally shooting Gazan in Terry Bessie's presence, Sweeney caused emotional and psychological injury to Terry Bessie's aggravating and pre-existing condition of post-traumatic stress disorder. Yeah, he got a cause of action for that. In regards to intentional infliction of emotional distress, yeah, he's got one for that. Terry Bessie also alleges that Ware's actions contributed to these injuries. Based on those facts, based on those allegations, it sounds like he has one to me. The district court based its decision to deny qualified immunity on this issue entirely on the facts surrounding the officers' encounters with Gazan. As noted, the estate of Gazan is no longer a party to this litigation. Nevertheless, we may affirm an appeal decision, on any ground which finds support in the record, regardless of the ground upon which the trial court relied. Okay. We have explained the Fourth Amendment protection against unreasonable use of force extends to the manner in which a search is conducted. Depending on the circumstances, a search may be unreasonable under the Fourth Amendment, even if officers do no more than threaten the occupants with firearms. Interesting. That's considered Assault. That's considered assault. The display of weapons and the pointing of firearms directly at persons inescapably involves the immediate threat of deadly force. Such a show of force should be predicated on at least a perceived risk of injury or damage to the officers or others based upon what the officers know at the time. Let's see. Even a show of force in executing a search warrant without actual harm to the property or person may be questioned on Fourth Amendment grounds. This is interesting. Some of this stuff I didn't even know. These principles apply a fortiori, or what, I don't know, it looks like a Latin word or something like that, to the discharge of weapons during a search, such that any reasonable officer must understand that his decisions to fire a gun during the execution of a search warrant is subject to Fourth Amendment scrutiny, regardless of whether he hits anyone. Now that's crazy, but it makes sense though. To me, it makes sense. Whether in this case the officers' actions were reasonable in light of clearly established law is not a question we may answer conclusively at this stage of the proceedings. As the district court recognized, the reasonableness of Sweeney's decision to fire his weapon depends in large part on whether Guzman did in fact attempt to wrest the weapon away from him. Whether Sweeney was blinded by the breeze from the stun grenade explosion, and whether Sweeney reasonably believed he was taking fire inside the house. The district court noted, moreover, that the credibility of Sweeney's recollection of these events was subject to genuine dispute. For the same reasons, we are unable to conclude at this juncture that Sweeney is entitled to qualified immunity for his decision to pin Terry Bessie with his shield, because Sweeney claims to qualified immunity rely on disputed facts. We have no jurisdiction to entertain them at this time. Sweeney has in turn raised questions about Terry Bessie's credibility, a matter that is also for the jury to decide and thus beyond our jurisdiction in this interlocutory appeal. We will disregard any disputed fact or facts that contradict plaintiff's version of events. Okay. Ware, for his part, testified that he fired his weapon because he thought that Guzman was firing at Sweeney. The credibility of his recollection and the sufficiency of the asserted basis for his mistaken impression that Guzman was firing at the officers or, like the factual arguments made by Sweeney, matters to be determined by the fact finder, which would be the jury in this case. They probably not going to let that go to no jury, though, unless they think they got a good chance of winning. We therefore affirm the decision of the district court insofar as it determined that the defendants Sweeney and Ware were not entitled to qualified immunity at the summary judgment stage in connection with their roles in the raid of Terry Bessie's home. Let's see, no knock-and-announce violation. It is clearly established law that absent exigent circumstances, the Fourth Amendment requires officers executing a search warrant to knock at the entrance of the premises to be searched and to announce their presence. Noting that the rule has ancient roots in the common law, was codified as a federal statute in 1917. Notice it's in a statute, y'all. Ain't no statutes in common law. Anyway, and has been treated by the Supreme Court as a command of the Fourth Amendment since 1995. Absent exigency, the police must give an occupant a reasonable time to reach the door, a time that will vary with the size of the establishment, perhaps 5 seconds to open a motel door or several minutes to move through the townhouse. The district court determined that the plaintiff's knock and announce claims could proceed against Brennan, Edwards, Lee, Phillipson, Sweeney, Torson, and Ware. The defendants argued that the exigent circumstances justified any violation of the knock and announce requirement. Let me see. Brennan, Phillipson, and Toroso deployed the stun grenades at the rear of the house. Lee was responsible for knocking and announcing the police presence, while Edwards breached the door. Sweeney and Warrant were the first two officers inside the house. Both fired shots. Okay. Defendants Brennan, Phillips, and Terreso argued separately that their part in the plan, which was limited to breaking a rear window and throwing two stun grenades into an empty room, was not subject to the knock and announce requirement, and that it was objectively reasonable for them to believe that the plaintiff would receive adequate announcement. The defendants, relying on the testimony of Lee and Edwards, also assert that the officers in the front entry team complied with the knock and announce requirement. The plaintiffs disputed this testimony, pointing to the video and audio evidence suggesting that the officers waited only approximately 5 seconds after announcing their presence to breach the door. Because this argument depends on disputed issues of material facts, we lack jurisdiction to assess it. Okay, that makes sense. The ordinary knock and announce requirement may not apply where officers reasonably suspect that announcing their presence under the particular circumstances will be dangerous or futile, or that it would inhibit the effective investigation of a crime by, for example, allowing the destruction of evidence. We consider the following factors as guideposts for determining the existence of exigent circumstances. So now they're going to decide if the officers had exigent circumstances that required them to disregard, in my opinion, the knock and announce requirement. The gravity or violent nature of the offense with which the suspect is to be charged, whether the suspect is reasonably believed to be armed, a clear showing of probable cause to believe that the suspect committed the crime, a strong reason to believe that the suspect is in the premises being entered, a likelihood that the suspect will escape if not swiftly apprehended, and the peaceful circumstances of the entry. In addition, we take into account whether quick action is necessary to prevent the destruction of evidence. No one factor is dispositive, and the list here is merely illustrative or exhaustive. The district court correctly concluded that qualified immunity was not warranted at the summary judgment stage. The plaintiffs presented evidence indicating that all of the defendants understood that the warrant was for a small amount of drugs meant only for personal use. The basis for the officer's entry, in other words, was related to an offense that was neither grave nor violent. As the Supreme Court stated in a related context, the application of the exigent circumstances exception in the context of a home entry should rarely be sanctioned when there is probable cause to believe that only a minor offense has been committed. Rejecting exigency as a justification for warrantless nighttime entry into the home to arrest drunk driving suspect. Let's see. On the version of the facts most favorable to Tara Bessie, then there was not enough evidence for a reasonable officer to conclude that the occupants of the house were so dangerous as to create exigent circumstances, despite the nature of the offense at issue. Apart from Tara Bessie's perhaps unusual intense adore for his pet bird, the defendants point to no evidence in the record suggesting that Tara Bessie would actually use force against the police. Maybe most tellingly, the officers did not seek or even discuss acquiring a warrant that would expressly have permitted a no-knock entry. While several officers testified to understanding that the knock and announce rule applied to this operation, and there is no allegation that any exigency arose after the operation began. Exigency may arise after the officers knocked the first time. Taken together, these facts suggest that the officers understood the circumstances prevailing at the time of entry, understood there to be no exigent circumstances that would permit dispensing with the knock and announcement requirement. Let me see. Although some officers testified to being told that Tara Bessie would shoot at them, Tara Bessie disputes their credibility. What is that? Sorry about that, y'all. The rake and break team. The defendants comprising the team at the rear of the house, Brennan, Phillipson, and Tereso, argued that the knock and announce rule did not clearly apply to their conduct, which was limited to breaking a window and deploying 2 stun grenades. Although the Supreme Court case law supports the proposition that breaking a window for the purposes of deploying a weapon triggers the knock and announce rule, yeah, I would suggest that too. Sounds like it. We need not address that issue here. On what is contained in the record on summary judgment, we agree with the district court that the actions of Brennan, Phillipson, and Tereso may have frustrated any attempt by entering the officers to comply with the knock and announce rule at the front door. 28. So there's a footnote. Let me see. Concluding that breaking a garage window for the purposes of pointing a gun inside constitutes an entry. Hell yeah, that constitutes an entry. But finding that exigent circumstances justify dispensing with the knock and announce requirement, stating that the detonation of a stun grenade is itself an unexpected and threatening intrusion, subject to the no knock announce requirement, setting out circumstances under which a federal officer may break open any outer or inner door or window of a house or any part of a house, anything therein, to execute a search warrant. The knock and announce rule gives individuals the opportunity to comply with the law and to avoid the destruction of their property occasioned by forcible entry, and supplies with them the opportunity to prepare themselves for the entry of police. For this reason, the knock and announcement rule must be loud enough to be heard, and it must be followed by a pause long enough for someone to answer or come to the door, suggesting that officers announce their presence too quietly to satisfy the purpose of the rule. Let me see. As the district court recognized, a series of loud and confusing announcements from all sides of the house may frustrate the dignitary and protective purposes of the rule. The district court correctly found that on the facts most favorable to the plaintiffs, Brennan, Teresa, and Phillipson might unreasonably have frustrated the purpose of knocking and announcing. After Phillipson broke the window, Brennan and Teresa deployed 2 stun grenades shortly after the officers at the front door announced their presence. Even after they detonated the grenades, the grenades caused glass to continue to fall and break while the officers at the front door were announcing their presence. At the same time, Brennan began shouting from the rear of the house, "Police! Police with the warrant, hands up!" At this stage of the case, the district court properly concluded that the defendant's actions could have disoriented and confused the occupants, I agree with that, of the house, depriving them of any meaningful opportunity to answer the door. I agree with that. You threw the stun grenades in. It sounds like they threw them in before they knocked on the door. Sounds like it. Let's see. Failure to intervene. It is widely recognized that all law enforcement officials have an affirmative duty to intervene to protect the constitutional rights of citizens from infringement by other law enforcement officers in their presence. An officer who fails to intercede in the use of excessive force or another constitutional violation is liable for the preventable harm caused by the actions of the other officers. Whether the officers had a realistic opportunity to intervene is normally a question for the jury. Unless considering all the evidence, a reasonable jury could not possibly conclude otherwise. We agree with the district court that insofar as the raid plan included the use of substantial and violent force, the plaintiff alleged facts suggesting that every defendant had the opportunity to intervene, and I agree, whether some of the defendants were in fact unable to intercede in the particular use of the force, either because they were not involved in the planning process or because of the manner, place, and timing of their deployment in the raid itself, is properly a question for the jury. I agree with that. Immunity from state negligent claim. Let's see. Connecticut law entitles municipal officers to a form of qualified immunity for the negligent performance of discretionary acts. The law provides 3 exceptions to this general rule. One, where it was apparent that The act would subject a person to imminent harm, where a statute provides a cause of action against a municipal officer, and 3, where the act involves malice, wantonness, or intent to injure. The district court declined to grant summary judgment on, on the plaintiff's negligence claim on state law immunity grounds, finding that there were genuine disputes of material facts as to the first and third prongs of the inquiry. This finding is not subject to interlocutory appeal. All right. That's it, y'all. We have considered the parties' remaining arguments and find them to be without merit. In light of the foregoing, we reverse the judgment of the district court insofar it determined that Chief Solomon was not entitled to qualified immunity from liability for the decision standing alone to activate the SWIRP tactical team. We affirm the judgment insofar as it held that Terabessi's claim implicated clearly established constitutional law with respect to the plaintiff and approval of the raid, to the use of stun grenades, the actions of officers Sweeney, Brian Weiner, and the alleged knock and announcement violations, and the duty of police to intervene in constitutional violations by fellow officers. In all other respects, the defendant's arguments on appeal rely on disputed issues of fact, and the appeal is therefore dismissed for lack of jurisdiction. This case is remanded for further proceedings. So they sent it back down to the district court. All right. So I'm sorry, y'all. Know this was a long video. It's probably an hour and 30 minutes. I don't know how long it is. Let me see. It's close to it. Well, it is an hour and 30 minutes. Sorry about that, y'all. But I thought this was a very interesting case. If you're interested in this case, I would try to find that case in the, what is that? Where did they file this? Somewhere in Connecticut, if I'm not mistaken. I would try to find that case if I were y'all, and I would read that complaint. And that complaint would tell you everything that you need to know, just in case if you wanted to use, like if something like this happened to you, this is how you have to draft your arguments and in your complaint. If the facts are similar, then all you have to do is you really can just copy and paste the complaints from one complaint to another, and then just make probably a few edits here and there, and you should be good. But that'll be the end of this video. The Supreme Litigant is out. Peace.